If you're new here, I'm Emily D. Baker, the badass lawyer, host of the Get Legit Law and Shit podcast and legal commentator. I've been a licensed attorney for over 15 years, but I'm not your attorney, not legal advice. I am a big fan of the Cursey words, so headphones are recommended. This is where the law nerds unite to break down the news stories that you want to hear about with facts, not fuckery. Good morning. Happy Tuesday. Happy Coffee and Cursey Words Day. I'm so excited to be here with you guys live. I saw all of you yesterday. You're like, we'll ride tonight. There's new documents. And I'm like, right. But my kids had to go back to school today and we had homework that we were in the middle of and I had a podcast to record. And I was like, I'm so sorry. I want to be live, but sometimes life, and we cannot be live all of the time. Also, the mods would have been like, no, we do not. What? Yeah. But, it's Tuesday. Stuff came out on Monday. We appreciate the consideration. It didn't come out in the middle of the night, which is amazing. I'm going to give you guys a heads up on what's going on this week, share some information with you. Then we're going to do a quick Girardi update. Then we're going to dive into all of the new documents. If you are watching on the replay, I will timestamp it if you want to go to the timestamps of the different topics. And what else? When I jump into the documents, I'm going to do all of them through, and then I'm going to do questions afterwards. So if you ask something and I don't get it pulled up on screen, I am sorry. I will do those all at the end. So I'm going to try to get through the documents and then just jump into your questions about them with a quick breakdown of like the status of the case and where we are in the case. It's so good to see you guys. And today is the first day I've started seeing the teal hammers. Where's my gavel? Oh, my gavel got moved. It's in the back. We need it. Teal gavel. Today was the first time I started seeing the teal gavels in the chat, which is very exciting. I'm super excited for your teal gavels. And those are for our members who have been members for 2 months, and the colors change. We've learned lots about YouTube membership in the last 24 hours, haven't we? It's quite the topic of discussion. So this week, let me share my screen. Professionals here, people. I haven't had coffee yet because we are back to distance learning at my house. So there's that. Oh, we don't need this yet. We're not pulled up just yet. There's distance learning again. So that is what it is. And we're going to talk about the podcast. And no, we don't. We're not pulled up. My screen's being sassy. So for those of you that are members, let me tell you what's going on this week. So today is Tuesday. Tomorrow we have a new episode of the podcast. I also have one other item that I want to, one other video I want to drop. So tomorrow at 11, there will be a new video. It might be the podcast. It might be a new topical video on another lawsuit. It just really depends on how smoothly distance learning goes today and if I can get it filmed, like full disclosure. It just depends on if my son is still trying to figure out the velocity that a Magikarp, if were it to jump over 1,000 feet in the air, because apparently Magikarp can jump over mountains. If said Magikarp jumped over mountains at an average Magikarp weight, which is a Pokemon, what would the velocity be if it landed on you? So that is what is being discussed at my house this morning. But there is also some very exciting stuff coming this week. So today, Wednesday, new video will be premiering at 11. The premieres are when I get to come in and chat with y'all. Thursday, we have members only live, and I'm going to be updating the members on that in the community tab. Friday is Friday Night Live. Oh, and I wanted to pull up the video we're at for the Nashville. Everyone who participated, I'm going to be putting it in the community tab today, but we are at that $3,250 donation. I will post the pictures of all the goods we took and then donated cash because they still need things for those who have been displaced. It's over 1,200 people who have been displaced from their homes due to the structural instability of the buildings due to the Nashville bombing. So we are I am continuing to track my AdSense. It's a few days behind. Let me just go and look and see if we're past the point that we've donated yet with AdSense, because I don't know if we are. So let me take a look on that real quick in the analytics and give you guys an update. So where are we? Back end. Yeah, we're right at that 30. And the reason we're at 32,050 still is because YouTube does take a portion of the super chats. I donated the entire super chats knowing that the AdSense would catch up with the portion that YouTube takes out of super chats. So I made sure to just hit that amount. And then as the AdSense tops that amount, we will go and donate it. But AdSense runs a few days behind sometimes. So that's where we're at. And I'll keep updating you. So wait, where is, I see my chat jumped. I was going to thank you, Uncannery. This is your first live, able to make it. So excited. Been waiting for your salty update since Uncivil's live last night. I know he was definitely able to get live and you guys were able to get kind of a first look, which is amazing. And I've read these. So this is a second look and then some thoughts on how I feel about it. So it's not a matter of where the Magikarp grips it for their velocity. Teresa, it is not a European Pokemon, but I appreciate the Monty Python reference. I'm old enough to understand and enjoy Monty Python, so I love that. Stacy, it's so good to see you in the chat. I saw you pop in, and I was going to pull that up, and then I lost you. Good to see you. Good morning, friend. Good morning. So work out the forces needed to reach. Well, that's what he's been working on, but I will absolutely show him the super chat. I don't want to tell him the answer. I want him to keep working on it because he was doing something in some physics, something in math. I don't know. His math is beyond me. AR said, using my new hairdryer, just had to say, sorry, off topic. It is the best hairdryer. That Revlon hairdryer, it is my favorite. Not sponsored, just I love it. And also like heavy hair dryers, like hurt your shoulders. Ella Rose, motion to get Salty to change his Twitter handle. I don't think Salty can do that. Here's why. He is using his Twitter in an official capacity. So as a lawyer, it's proper to represent yourself accurately as who you are on social media. So you're not going to see him saying he's gathering evidence under a Twitter handle that's not his, because that can create other problems. So he's going to still go just by his full name on that, because he also puts that in declarations, and we will see that as we jump into it. But wouldn't it be funny to have Salty be Salty? I don't think he can do that while this case is pending, though. So thank you, Lori Smith. We ride at 11 a.m. Look, y'all, the only way I'm up at dawn, let's just be perfectly honest, the only way I'm up at dawn is if I haven't gotten to bed. Thank you from snowy Yorkshire. Thank you so much. I haven't gotten to watch all of Uncivil's video, so I will give you my take, and then I will go back and watch his and compare and contrast. I wanted to give you one more update. Where is it? I pulled it up, and I'm not seeing it. Hold on. There was one more update I wanted to give you guys about the podcast, because new podcast is launching tomorrow. Well, not new branding, same podcast. So the Get Legit Launch It podcast is switching to the Emily Show. Some of you might have already seen that in your podcast player. Some of you might not have, but the Emily Show is the new branding of the podcast. So tomorrow, when the podcast goes live, this is the new album art and the new name. So the Emily Show will be in your podcast player tomorrow. For some of you, it might already be there if you're on Apple. And you don't have to resubscribe or anything like that. The name and everything will just update. Same kind of content, slightly new. So I don't keep getting throttled in search for having shit in the title is truly the biggest part of it. So that's absolutely what it is. So the Emily Show launches tomorrow for season 3 of the Get Legit Launch It podcast, which has been trending in news commentary and will continue to do so. I also do a little quick election update in tomorrow's episode. Today is the Georgia runoffs. Tomorrow, the Electoral College meets. There's a lot going on with our election. It's stressful. We're just going to. Myra M., I love the shade that Uncivil did yesterday in his live. I couldn't stop laughing. Halo needs to give him a sponsorship. I mean, I don't know. Has Uncivil tried Halo? I'll hit him up and be like, have you tried Halo? I wonder if he's tried it, because all this talk of Halo, it makes you like, hey, do we not? Do we try it? See, it is Dawn somewhere. I knew it was Dawn somewhere. This is a fair point if it's a shiny Magikarp. I love those gold Magikarp. I have a couple of them. All right. Without talking about politics, because we are just moving well on from that, because enough shit's going to hit the fan on that today and tomorrow. And today's our escape from politics. So if you bring up politics in the chat, Diva's going to be like, Emily doesn't even want to scroll it because it's stressing her out and she doesn't need anxiety. So we don't need anxiety. Passenger saying, you're so sweet. I literally put it on a tripod with my iPhone because I have a window right here, and that's what I did. And I used my Apple Watch because you can press screen release. I'll do a video on how I do that, but you can remotely trigger your iPhone from your watch, and then it gives you on the screen, it will show you your camera. So you can have your camera facing you like this on your phone and then on a tripod, and then use your watch to see what your camera sees and to hit the trigger. That is the secret to taking selfies with the back camera if you have a tripod. And the tripod I use should be in my Amazon store, just because otherwise I forget what I bought, but I keep it under my desk. You never know when you need a tripod. This is how I go live on Instagram. This is it, folks. That's the magic. A $15 tripod and a very expensive Apple Watch, but it makes it work when you don't have like a photographer on hand. Though the woman I have used for brand photography is moving to my area, so that'll be really fun. All right. Thank you, Jake's Baby Cakes. I agree. No politics. We are going to do a quick rundown of what's going on with the Girardis. They have another hearing today. For those of you that aren't following the Girardi case, Erica Girardi, aka Erica Jane, is a Real Housewife of Beverly Hills. I actually quite enjoyed her on The Real Housewife of Beverly Hills as a character. Her son's an LAPD officer. She was a single mom. She has always wanted to be an entertainer. You know, Hollywood dream, moves to Hollywood, marries a rich dude. All her dreams come true. She has all the money in the world to spend on music videos and glam and all the things. Love story made in heaven. Her husband is this famous ass attorney who has multi-billion-dollar settlements. He's very well known within the plaintiffs bar. That means people who sue, the ones who sue are the plaintiffs, unless it's criminal. And in the plaintiffs bar, he sues for people who have been injured due to work conditions, environmental conditions, major air disasters, things like that. And then the entire house of cards crumbled. And it looks like it has been crumbling for a bit, but this federal lawsuit thrust it into the spotlight because really we've moved from like 2020 tsunami to apocalypse of all the lawsuits. And there are so many lawsuits now saying that clients haven't been paid. And in law, like when the money comes in, so the case that kind of tipped everybody in this direction is a Lion Air case. Lion Air was one of the flights that had a Boeing disaster there were two close in time with one of the Boeing models, and it got grounded for a year and a half and is now finally just flying again after they've updated some software and some other things. So he and his firm, Girardi Keese, represented a number of the surviving family members of victims who lost their lives in that plane crash. There is another law firm that worked with him on it. Settlements were reached with Boeing. Settlements were paid to Girardi Keese. What happens is it just goes into its own little client account, and then it's supposed to be doled out. And the attorneys get their costs, like the actual money they spent. Then they get their fees. Then it goes to the clients. And that's generally how those settlements work. And it goes into a trust account and then just gets doled out. The other law firm is like, where's the money? Because it looks like the people haven't been paid. And that's confusing because you got the money from Boeing, but we haven't seen it and we haven't seen an accounting, and WTF is even happening with this. And then all the wheels came off. The judge is like, there's a settlement and you got the funds, just pay the funds. You owe $2 million, pay $2 million. And for those of you that watch Real Housewives of Beverly Hills, you're like, don't they have like $2 million in a couch cushion somewhere? Like that is the level of money the Girardis purport to have. Isn't the money just, can't you just, sell a pair of earrings? Where's the $2 million? So then all the creditors started coming out of the wall. Wells Fargo, multiple lending services, because when you take plaintiffs' cases like that, the attorney fronts the money. So the attorney spends the money, pays the people, does the investigation, and then recoups the money out of the settlement on that's a contingency. So instead of paying the attorney every month, you do it on contingency where if we win, we're going to win this amount of money or settle for this amount of money. I'll pay back my debts. So there are lending services that help attorneys float the difference. And attorneys with good track records, I imagine, have an easier time accessing those types of lending services because they'll put millions of dollars into a case before it resolves in investigation and costs. So there are multiple attorney lending services that are like, we haven't been paid. There are the past partner from the law firm who was supposed to be paid out on property. There are property cases because the business is encumbered with debts and it's not supposed to be, all kinds of stuff. Assets were frozen for Tom Girardi from the federal court, and then a number of the creditors filed for Chapter 7 bankruptcy, forcing Tom Girardi and Girardi Keese into bankruptcy, and that is going to end up effectively pulling Erica Girardi into bankruptcy. Though she's not a debtor, she is still married, so marital property is going to get pulled into this as well. He has not shown up on the bankruptcy at all. There was a motion yesterday to have a interim trustee appointed. That means we're going to cover the estate, freeze all the assets, and start doling it out and dealing with it in bankruptcy. Girardi and Girardi Keese have not shown up on the bankruptcy at all. They have not shown up in court. They have not contested it. I don't think anyone has even seen Tom Girardi in public. No response in the bankruptcy case at all. And there's not much going on in the divorce case at the moment. He was trying to have the court in the divorce case say that they're not going to seek spousal support. Who even knows what money will be left by the time we get to the end of the divorce case? And there are more hearings happening in that case today. Erica has not been held in contempt of court. There was an order to show cause. You're going to hear me call it an OSC, an order to show cause, why she shouldn't be held in contempt. Her attorney was strongly reminded by the judge. Sometimes we call that being admonished. Her attorney was strongly reminded that her assets are marital assets and she cannot be selling them off while there is a freeze asset order in place. So things are chucking along. More creditors have come forward. A lot of paperwork has gone down in the bankruptcy case. Tom Girardi's son-in-law, Lyra, just stepped away from his firm. And I want to show you the shade. They just deleted him out of the existence. So in the federal lawsuit with regard to Tom Girardi, they also sued Lyra, the son-in-law's new firm, saying that that new firm might have information or might be part of the accounting because Lyra would have known and he left to that other firm. And perhaps that other firm has some involvement that they want to discover. So he was working at a firm that was Johnston, Hutchinson, and Lyra. That firm is now just Johnston Hutchinson. And when you try to find him, when you try to find David Lyra, look, I'm going to show you on the Google. Google, don't fail me now. I had just pulled this up, but on the firm, his page is not found. His page 404s, they've got the new copyright from 2021 that's showing it's just now Johnston and Hutchinson. It was Johnston, Hutchinson, and Lyra. So we've got a 404 error on the page. I think he's been removed off of the team completely. So he has been axed out of this law firm. It looks like he quit, but he has been removed from their website, probably because they don't want to sustain the difficulty of being associated. But he was the third partner. So when you go, David Lyra, attorney, let's get rid of declaration. We can go to this would have been his page. This was their old website, JHLLP. So Johnston, Hutchinson, Lyra, LLP, legal, limited liability, legal practice is essentially what that stands for. And his page is gone, the shade of the whole thing. And they changed their URL. They are now just johnstonhutchinson.com. I wonder if they owned that URL before, or if they were fuck, I hope it's available, because it looks like their URL used to be JHLLP. So there is quite a lot going on. And then in the LA Times article, they talked about the fact that the declaration was filed from Lyra saying he had been telling Tom Girardi to send the money. He left the firm over the summer and went to work with Johnston Hutchinson, and then became a partner, named partner, Lira. That's a big deal for attorneys. Having your name on the thing is a big deal. It's a big deal. It's important. So now he looks like he has stepped away from the firm he was a named partner at and is dealing with the scandal of all of the things. So the shade of it all. We will see what happens in the hearings today. I will be updating it on social media, on Twitter and on Instagram, because those aren't happening until the afternoon. And I expect the judge's order to be in from the hearing yesterday in bankruptcy. But right now they have Tom Girardi representing himself and representing Girardi Keys pro se, which means by, you're representing yourself. And he hasn't shown up. Like, no notice of appearance, no nothing. I'm wondering if he's just going to bounce on the whole thing and be like, whatever, we're bankrupt. Good luck finding any money. Like, I'm shocked that that's the way that that's going to go. The people who are going to get the short end of the stick in all of this is the people who don't have judgments yet. So any of the clients who are still in the process of suing and don't have a perfected judgment, meaning a signed by a judge judgment yet, are going to be towards the bottom of the line of creditors, because some of these are secured creditors. It'll be very interesting to see how the order of supremacy, essentially, in bankruptcy will work with secured creditors versus unsecured creditors. I have seen one of the clients starting to argue that they are not a bankruptcy creditor because it's a breach of contract and they were a client, but they're owed money. At this point, it'll be interesting to see if the bankruptcy court says no for these clients. They are clients that are owed funds. They're not creditors, and put them in a different class. But at the end of the day, he owes them money. They're going to have to get in line with the creditors, is what I think the bankruptcy court will do. So I'm going to check in and answer a few questions, and then we're going to switch topics over to the filings yesterday. And I'm just going to go through them, read them, and give you my thoughts and answer your questions. That's what we're going to do, and have some coffee. So let me go and see what questions we've got. How are you guys doing this morning? I feel like I've been talking very quickly. I feel like I've been talking very, very fast. YouTube does that. Oh, and I forgot to send out a text this morning. Sorry, text crew. I generally remember, and then I was talking to my kiddo and I totally forgot. I should do that now. I can still do that now. While I answer questions, I can still shout out the text crew. You guys, the chat is moving so fast. It's on slow mode and it's still moving really quick. If you're in the chat, if you are on your phone or whatever, you can hold it and it'll slow it down just a little bit, but it can still be tough. So let's just remind sorry, text crew. It's like 20 minutes late. I'm the worst. Not really. Kind of. Sometimes I forget things because I get excited and distracted. And this is why I'm very upfront about the fact that I'm ADHD with y'all, because then you understand. You're like, oh, this is Emily's ADHD. She started talking about the velocity of Magikarps with her kid and totally forgot to send out a text. Because that's what happened. So, and then I'm going to have to go wish people. We have 6 people in the text crew that have birthdays today. So if it's your birthday in the text crew, you're going to get a birthday message from me after I'm live. We're going to just, sorry, I'm late. We are live. This is how it happens contemporaneously. All right, text crew. Sorry, y'all. I also got distracted by the teal gavels for our members. I did. I really did. All right, let me see what questions I can grab through. So this is Annie. This is hilarious. Yeah, Erica's definitely being named as a doe in a lot of these. So they are absolutely pulling it in this is why you name does in different cases. Because as the federal case came out and alleged that Erica Jane's company got a $20 million loan from Tom Girardi's company. So as that happened, people who have the does alleged can just say, okay, doe number 1 is Erica Jane, aka Erica Girardi, or it would probably be Erica Girardi, aka Erica Jane, and then pulls in the person without having to file all kinds of new stuff. So it helps a bit. Ella Rose asked, is there any indication that this is an acrimonious divorce? Well, she doxed a federal judge saying that was a person her husband was having an affair with, but the text looked old as hell. So the federal lawsuit is alleging that this is a sham divorce. Erica hasn't said anything about it. Tom hasn't said anything about it. Tom went in and said that he doesn't want to pay spousal support, but I don't know if we can gather what that's from. So I don't know. I don't know. I don't know. So we'll see about the divorce. The divorce is either, I mean, I see it three ways. Either maybe they are trying to do what's alleged in the lawsuit and get divorced to try to shuffle assets. That's not going to work. Assets that were previously shuffled is a different story. She just found out that this is what was going on and was like, oh, this is gross, I'm out. But in that case, I would have expected some kind of a statement. Or she's just like, oh, I can't survive this. And this is the Titanic. I see that it's the Titanic and I'm out. I don't know. Or maybe he was cheating and all the things. I mean, I don't know how you would have the energy with all of this going on and the world of stress that this must be causing. I can't imagine how stressful this is. Like it is literally a house of cards collapsing in with all of these suits. Unless I don't know how anyone would not be just like, I don't even know how to survive this. Like we just one step in front of the other. It's so much. And when I say I've never seen anything like it, I've never seen anything like it. I've started following the LA Times writers that are covering this. And I'm like, when is someone going to interview the state bar? Like I have so many questions about why plaintiffs weren't on notice from state bar actions that this kind of shit was happening. Like, how did this go on? And it looks like for years, this kind of Madoff pyramid scheme of grabbing money from like, oh, I just settled this, so now I can pay off this debt. And I just settled this and pay off this debt. And the people getting lost in all of it were the plaintiffs who were injured, which is why it makes me so ragey. It's just. So let me see let me grab a few more questions. I love seeing you guys chat with each other. And that's sometimes my questions get in there because it's just, I hope I pronounced this right. Kamoil. If I pronounced it improperly, I apologize. Your girl's dyslexic and pronouncing things is hard. A lot of law firms look like that. A lot of Los Angeles law firms look like that. And it is a whole ass situation. It's a whole ass situation, but there are quite a lot of law firms. Also, notice all the partners are dudes. That happens too. We did not talk about Tati yet. We are getting to it, and I'm probably a little bit behind on the chat. I want to make sure I get questions on the Girardi updates, and then we're going to shift over. Welcome for your first time catching live. It's so good to see you. I'm going to try to get to Bijou. So has Lyra appeared anywhere else? Was he fired? Does this suggest he is toxic? I don't know if he was fired or if he chose to step away to protect that firm from the scandal of it all. And it might have been to protect that firm from getting roped in. It looks like he left Girardi Keese over the summer and joined this other firm. That means those are building monuments to the gods of speculation. It means that those are probably attorneys that he knew, that he chose to work with because he had a good working relationship. He came on as a partner. It's a smaller firm, so it's probably people, he wasn't headhunted, I would imagine. It's probably people he already had a good working relationship or had worked cases together with or is friends with, because, lawyers have friends that are other lawyers. And so he might have wanted to protect them from the taint of the scandal that is brewing, because he is getting pulled into this as a defendant too, because he worked with Girardi Keese at the time that this all went down. And again, this is also his father-in-law. So there's like the personal scandal of it all, but then there's also the business scandal of it all. From their declarations, as reported by the LA Times, it looks like the attorneys were like, what is fucking happening? But of course, that's their statement now, right? Like, pay it, handle it, deal with it. The judge is going to want to know, well, why didn't you tell me? Like, if you were saying that in June, why didn't you come and tell the court? Why did you just leave the firm? Did you do your duty to these clients? So there is a lot more that's going to unfold here. There is now indication that some of the settlement class plaintiffs maybe didn't agree to settle this case. If that ends up being something that is true, the mess is going to expand. It is like, it's not just shit out of the horse. It's like out of the horse, run over, smeared on the walls. It's going to be so messy. So there is now in declaration some indication that that might be the situation, and we won't know that just yet. So we're still at the precipice of this entire Girardi scandal. There will be more hearings. The thing is, if the bankruptcy court pulls everything in but the federal case, we will just keep following what's going on in the bankruptcy court, and we won't see much else. It'll pull all those other cases in and deal with them. The federal court, I think, because a settlement's already been reached, will not necessarily get pulled in, but could, because payments still need to be made. So we will see if everything ends up under the umbrella of the bankruptcy court. And interestingly enough, the first bankruptcy judge that was assigned promptly recused herself from the case and was like, nope. And that might be because that judge had a working relationship with some of these firms or with Tom Girardi, because there are quite a lot of law firms involved. It's a lot of lawyers. It's going to be like herding cats in that fucking case. It is so many law firms at this point, because it's law firms representing law firms, and then law firms representing debtors, and then the Girardi case firm in and of itself. In order to include marital assets, would they have to prove that she was aware and participated? Victoria, not in the bankruptcy. The bankruptcy, you don't have. If you guys have seen Pretty Little Lies, it goes into bankruptcy, and the husband, I don't even remember what he was doing in that show. He was doing something and they ended up in bankruptcy, business dealings, I don't know, gambling, but they pulled everything in, and she's like in the bankruptcy court, like taking off her rings as they're trying to evaluate what everything's worth. And it's a very dramatic play out of bankruptcy for them, but it's dramatized, but it's not inaccurate. So when their marital assets and debts are owed, marital assets can be attached for debts that are owed in bankruptcy, even if you didn't know. So aside from the Girardi situation, if you have somebody who's wealthy and has a lot of assets, and somebody rakes up or has not even a salacious, let's go with not a salacious example. Somebody owns 5 restaurants in Los Angeles and have been shut down since, last March, off and on, and just cannot afford to go forward, and decides to shut them all, but then is sued by a landlord saying, hey, but you owe us this back rent on these 5 locations. And then they file for bankruptcy. Those marital assets can come into the thing, even if you don't know that the restaurants are struggling that much. Maybe it's a bad example because of COVID, but you don't have to be responsible for the thing. The assets are joint, which means if your spouse owes a debt, you owe a debt, joint assets. This comes up a lot if with medical debt, people who need to go into bankruptcy due to medical debt. You will see sometimes people trying to get divorced because of medical debt. The fact that anyone in our country goes bankrupt because of medical debt's a whole nother conversation, but that's a whole different conversation that I'm aware enough that it can get political quick. But either way, there are some actual new bankruptcy rules because of COVID that just kind of popped through. So there are some new quirks to bankruptcy. It's very interesting. COVID has changed so much, and bankruptcy is one of those things that COVID is going to have a big impact on. So what does it mean career-wise when you become a partner? So Stephanie, I have never been a partner in a law firm. So, at the end of Legally Blonde, when she's like, if I'm going to be a partner in a law firm by the time that I'm 30, it's a big deal for the ego. It makes you feel good because you're a partner. You're a partner. But in larger firms, it also means that you have an equity share in the law firm. So if you're an equity partner or not just a name partner, if you're an equity partner in a law firm, it means that all the money the law firm makes, you get a share. But you also have to buy in. So when you become an equity partner, if there's 5 partners and you're the 5th, you're buying a 5th of the firm. So you're paying in to become an equity partner. And then if the firm makes $5 million a year profit, then that money gets divided up equally among the equity partners. There are also name partners who don't buy in, but their name is like the name of the law firm. And so that's where you get the Johnston, Hutchinson, and Lira. You're a name partner because your name is part of the firm. But in larger firms, becoming an equity partner means kind of you've made it. You also then have a little more freedom in choice about the kinds of cases that you work on. You have associates that work beneath you, and you're kind of one of the top dogs in your firm. And you are managing other lawyers at that point and then doing the work that you like to do the most. Oftentimes, it is the partners that are the trial attorneys in litigation groups. The inner workings of large law firms is not something I'm the best at speaking at because my work with large law firms is tangential and limited because I was mostly a attorney for the government and then I worked for myself. But I do have a number of friends who work for very large law firms, so my experience comes secondhand with that. But that's what it means becoming a partner. It is A, there's an equity part of it. B, there's an ego part of it. C, it makes you fancy. But then there's also responsibilities and obligations to bring in clients and law is changing so much. I imagine that we'll see this change. Whitney said, any money Erica makes from Real Housewife probably goes through her own company, EJ Global, probably, which could then be considered marital funds due to the $20 million loan Girardi's firm made to it. It wouldn't be considered marital funds, Whitney, but you're on the exact right train of thought. Like we're on the same choo-choo of thought. It is because EJ Global owes Girardi Keese $20 million, depending on if that is true. That's an allegation in the federal suit. Then because Girardi Keese is in bankruptcy, the bankruptcy court's going to be like, excuse, you have $20 million that we need to pay all this shit back? We're calling the loan so it can come in that way. But it's not just because they're married. It comes in that way. Let me make sure I get to a few more questions, and then we are going to pop in. Jake's Baby Cakes, you make an excellent point. Excellent point. The Girardi case is one of the most disgusting things I've seen. And again, there are a lot of allegations. It's so many allegations. And the federal judge is just like, I'm not fucking playing. Pay the people the money. And I'm like, the federal judge is like, no, you owe them the money. Where's the money? So we know in the federal case that there was a settlement reached and the money hasn't been paid. Like we know those things to be fact. That alone is enough to put me over the top because no client should be chasing down money like this. But damn, when we start seeing the whole house of cards, damn, look, in medicine, they have the kind of do no harm. There are ethics in law. And I know for people who have had negative interactions with lawyers that it feels very weird that there's ethics in law, but I take the ethics in the profession I chose to go into very seriously. And when others don't, it pisses me off. I'm also an Enneagram 1. I'm like, how fucking hard is it to do the right thing? It's not hard. It's not, money comes in. There it goes. HIM says, question, does this mean they were living above their means? Why steal client money? He must have been paid really well. I don't know. The question I have, and not the one question, because I have questions about the bar. Y'all know how I feel about that. The question I have about the money is what was the first like pay it? I need to grab from here to pay here. And that could have been overextending in a case that didn't come through, spending $5 million on a case that didn't settle and needing to pay back creditors. That could be, I don't know, that could be funding Erica Jane's music career. We don't know. But where was the first shortfall? And then I don't know where that first shortfall was. And there's an article that I've linked in a couple of my videos from the Daily Breeze in the Southern California that indicates that these suits go back into the 90s with these types of allegations. So that this behavior would have predated Erica Jane being on the scene. So I'm very interested into where was that first, like, oh, this money has to cover the last lawsuit. I don't know where that tip started, but once you get there, it looks like there was no getting back from it, or at least they didn't choose to recover from it. Could Tom Girardi flee the country? I mean, things can happen. It made more challenging by COVID, though, thankfully. Like, it's going to be a lot harder to hop to the Bahamas right now. People are also, I imagine, keeping an eye. I don't know if they've well, with private jets, I don't know if they take your passport if it matters. But with his assets frozen, he might not be able to access his jets. Fleeing the country would definitely be a bad look. Could it happen? I mean, never say never. It would just be bad. It would just be bad. It would just be bad. Did Emily cover the story that Erica hasn't lived with Tom for 3 years? I didn't know that, Lori. But even if she was separated for 3 years, it's not going to help in this case. But I didn't know that. I know she had an apartment. I didn't know it had been 3 years. So, I mean, what I know is that nobody's really seen um, Tom out and about, and his attorneys have given some indications that perhaps he's not understanding the gravity of the situation. So they're leaning into maybe it's a capacity issue. So we'll see. All right. I'm going to keep moving on. Let me see if I have any more questions on this before we switch topics. You guys don't forget to hit the like button. And I'm just going to plug, because there's almost 5,000 of you here. If you guys don't follow me on the socials, I would really appreciate it. Also, I will keep you up to date when shit happens quickly, because I don't always drop on here the second stuff goes down, though I try to. All right. This is the greatest comment ever, Linz. Miranda's job on Sex and the City makes so much more sense now. Yes, as you start to understand the lawyerly things, you start to understand it. And you start to understand why she was like, oh, I need to have a life that looks this way to fit in with the partners of the firm. And firms are changing. Law is changing, but it changes slowly. Eric and Tom do not have a prenup. No, she said it multiple times. It's shocking. But she said it would be pointless as Tom's such a good lawyer. Well, it's going to be pointless because there isn't going to be any money left. So, all right. Let us hop through the last ones. My mom worked for Pepper Hamilton and Sheets. After 100 years, Sheets was just dropped. Just after 100 years, it's like, we don't even remember Sheets anymore. Drop the name partner. I wonder if they have legacy contracts in there that you keep the name. Sometimes you keep it for goodwill, but that's very, very interesting. Super interesting. In the UK, you don't really get name partners. The UK runs so differently with the way they do solicitors and barristers and things like that. It's just such a different system in the way that they do it. Which also fascinates me. I love learning how legal systems work in other places is fascinating. And at the DA's office, there were often opportunities for people to go to other countries they generally had a connection with. We had a really diverse population of DAs, but to go to other countries and talk about things like domestic violence, sexual violence against women, things like that. And so they often would go and learn about other systems and say, this is how we handle it in our system, and actually help have conversations about laws and changing laws. And it always fascinated me. Ella Rose, was there ever a question as a DA that I wanted to turn down? Oh, I turn down cases all the time. I actually was a filing DA for a while, and I'd read it and be like, yeah, what we're not doing is that. So I turned down more cases, I imagine, than I filed. And there were cases that I definitely advocated for having dealt with in one way or the other. And I addressed that a bit in my podcast episode, answering your questions. So I don't want to go into it too much in depth as we're getting ready to talk about a different lawsuit, but I do go into that. And there were cases where victims were mad when I advocated on behalf of justice, which sometimes means the person's not prosecuted to the ends of the earth, because that is not always the appropriate outcome. And some of those cases are still hard for me to talk about, so I don't talk about them specifically just because the facts were so tragic. But I dealt with a lot of vehicular related homicides, and those cases were always really hard for me because they were mostly tragic accidents. They weren't all, I mean, there was just a case in San Francisco where somebody intoxicated, it looks like, ran down people in a crosswalk. They weren't all like that. Some of them were much more circumstantial and very, very sad. So there were definitely cases that I turned down because that's like your job as a prosecutor. You're kind of the first stop. Question: how are offshore funds dealt with? Can they find them? That is the question. Can they find them, and can they pull them back into the U.S.? It's very hard to pull things back into the U.S. if they find things. So we will see. I don't know if money's offshore. We will see. Sorry, Truth, I sent the text out late. We're here every Tuesday at 11, but I totally sent the text out late. I'm sorry. Question, what happens if there's no money to pay out? Well, dinner's ready. They sell everything that they can sell, and then the people who don't get money don't get money. They can try to attach Erica Jane's future earnings from Real Housewives. I don't know what future earnings Tom Girardi is going to have unless you can make them sell off stocks and properties and vacation homes and cars. So they will sell everything that they can sell. MJ, I hope this question makes sense. If this scheme went on for years, how was he able to get money from lending companies for the newer cases? I don't know. I don't know. And it might have been that he always pulled from back cases to pay the lenders so that they didn't know that they were being paid from a different case, not this case. There's one filing from one of the lenders showing this long chain of conversation where the lender was like, no, we were supposed to be paid out of this case settlement. And he's like, oh, I misunderstood. I've got another settlement coming in and I can pay it. So there's indication that that's what's going on based on emails between the lender and Tom Girardi saying, no, we lent you money for case A. When case A settled, you should have paid us. But what probably happened based on how that email read is that the money from case A went to go pay case Z, and that they were hoping the money from case B would come in and pay case A, like that classic pyramid scheme of the money coming in to pay off other people to keep it all going and not, keep all the balls in the air. I've mixed so many fucking metaphors today, y'all. I am so sorry. Your horse analogy reminds me of a parade I went to where the horses relieved themselves and the gymnastics team was behind them and didn't notice until it was too late. We're just going to take a moment. That's incredible. When I was in high school, I was in band. Shocked. You're shocked that I was also a band nerd. Shocked. But I moved from band into pep squad because the outfits were cuter because I'm basic. And there was a holiday parade we did, and it was the 90s. There was a Barney character tripped and the head fell off. Kids lost their minds when it was just like a Barney costume with a dude head sticking out. Oh, I can't imagine a gymnastics team with horse poop. I heard Estonia is running a pilot where AI runs small claims court and makes decisions. Oh, that would be very interesting. I don't know if you could do that here under our constitutional rights. That would be very, very interesting to see if you could. Question, did you know Alan Jackson from the LADA's office? I did know Alan Jackson, GGB, and I know he is representing a federal judge that was doxxed by Erica Jane. I've been tempted to email him and be like, hi, Alan. He actually ran for district attorney, and then when he did not win the position of district attorney, chose to move on into private practice, which is not uncommon at all. Royally Rhonda makes an excellent, excellent point. Okay, I'm going to try to keep up a few more questions. So at the end of the day, how do the victims get paid? Dinner's ready. Hopefully they sell what they can sell and pay them, but they're going to have to get in line with the other creditors. And we will see how that plays out in bankruptcy court. So, Rachel, I have not looked at that question in a long time. Can they touch 401k plans? I would have to look. I don't know specifically off the top of my head because the bankruptcy rules have changed since I heavily studied bankruptcy in law school because I was fascinated by bankruptcy and still am. Okay. I want to make sure I get any other. Do you think Tom paid for Erica's spot on Real Housewives of Beverly Hills? Does that happen? I don't know. I don't know how people become housewives. Like, I don't know how that works. I don't know. I know it definitely revived her music career for sure. For sure. This is amazing, Beauty Junkie. I love Costco so much. Hello, Costco shoppers. Beauty Junkie is amazing because she is here. That is absolutely a possibility that Girardi is sick and just doesn't care. And that's why he's not showing up in the bankruptcy. Absolutely, absolutely, absolutely. Question, partnership financial liability for what the other partners do. So in Girardi case, the only equity partner was Tom Girardi. So I don't know how that will play out. Iona, what if the $20 million loan was the start of the pyramid falling? It would be interesting to know that, but her company's going to be on the hook. That doesn't mean her company can't just turn around and file for bankruptcy, but her company's going to be on the hook for that loan for sure. Okay, guys. So we have an involuntary bankruptcy. We have assets being frozen. We have all the things in the Girardi case. I will absolutely keep on top of it. Sounds so weird to say keep on top of that case. I'm going to keep following all those cases. I'm fascinated, and I'm just fascinated. I'm shocked. I'm fascinated. I'm shocked and fascinated. And that is a perfect segue into the KJ case. But we have two questions, so I'm going to get to them and then I'm going to move on. Pink Piggy, why don't they allow the victims to be paid first? It's going to depend on how they categorize them. So I don't want to say like this is for sure going to happen, because I can't say that this is for sure going to happen. In bankruptcy, creditors who are secured go before unsecured creditors. So a secured creditor is someone that has a guarantee of some way, like a personal guarantee. And those are going to be some of these lending companies and things like that. But will a court look at that and say, yes, but based on the contract, they are secured, or based on the contract, this is just a breach of contract and they're not paid? It really depends on what the court does. I hope that the court puts them at the top of the line of secured creditors. I don't know how that will play out in bankruptcy court, but it's something I'm going to be looking into to do if other shit would stop happening, to do a deeper analysis of this and see if there is precedent for clients to be considered secured creditors. I don't know the answer. So why don't they? Because bankruptcy has rules, and if they're not considered secured creditors, they're not going to go in line. Now, the ones who already have judgments, that have sued to get their money and have judgments, there's an 11 million judgment out there from a past client or group of clients. They already have a judgment. So that judgment's going to bump to the top because that is already a perfected judgment. Others who just don't have their money yet might not fit into the same category depending on how the court determines it. Question, can the California Bar Association be ringed into this lawsuit for not giving him any disciplinary or not noticing? I have a lot of questions about that. And I wonder if a number of the plaintiffs won't sue the state bar saying he should have been disciplined and he should have been disciplined. And because he should have been disciplined and wasn't, we were hurt because we ended up hiring him. Because if you go to Cal Bar and look up his name, there's no disciplinary action. You would never know that there's all this stuff outstanding. So we'll see. Yes, I think Chartreuse Seeker, all of us want the victims to be paid, first of all, for sure. Young Fox, I know. I wanted to make sure I got to the super chats and didn't miss them before we moved on to topics. Illinois has a case where a public official embezzled over $53 million in 20 years. The liquidation was amazing to follow. They sold everything. They're going to sell everything. It'll be interesting to see how much like the Cartier Jaguar ring goes for. And I think some of the things from Erica Jane that get sold are going to go for maybe more than market value because they're hers. And there are people that like that notoriety attached to the things. So we will see. All right. Hello from Tijuana. I'm so glad to help you learn something beside medicine. So thank you for the super chat that says hi from Tijuana, Mexico. Thanks for helping me learn something besides medicine. All right, y'all. So we're going to coffee. And we're going to jump in. All right. And I saw Adam McIntyre pop into the chat. I saw Jen Girard pop into the chat. Truth Sleuth, I saw you in the chat. So I wanted to say hello to everybody. Monty, tell Monty that he is gorgeous just the way he is, and don't let the haters get him down. Hello, Monty. All right. Moving on from the Girardis. I need a palate cleanser. I love that Def Noodles has started doing the palate cleanser. Let's get into Saltsy. I feel like we need music to switch it over. I need to do that. I will pull in some of my podcast music into this. So when we switch topics, I can just put in a little music break and we can just have a moment because I had that music written. All right. Let's go. Let's get into Saltsy stuff. So I'm going to make sure I have it pulled up. We have two things that have been filed. We're going to give you a brief rundown of where we're at. All right. The Tati Westbrook defamation suit is one of the two suits going on right now. There is a defamation suit and there is a business partner lawsuit over Halo Beauty and Tati Beauty. We are talking about the defamation suit today. Here's what normally happens in a suit like this. A defamation suit or a lawsuit will get filed, then there will be an answer and or some type of pre-answer litigation. Pre-answer litigation can be things like a jurisdiction motion, things like quashing service of a subpoena, saying for some reason this isn't proper yet, so we're not answering it yet. Or there can be negotiation for settlement before an answer is filed. So we're not filing an answer yet. We're not saying that we didn't do all the shit you said we did yet, because there's other things that need to happen before we do that. So in this case, that's not exactly what happened. There was a defamation lawsuit filed just a few days after the business partner suit was filed. After the defamation lawsuit was filed, stuff on social media allegedly started disappearing, and then there was a motion to preserve evidence filed. Up here with the law nerds, we call it the motion to not delete your shit. That was filed. As that started rolling along, the response to the lawsuit was filed, and the response came in the form of a motion to dismiss on multiple grounds. I mean, not that they were cited, but from what we can divine from the ether, on multiple grounds, and that is a jurisdictional motion and a 12b6 motion to dismiss with regard to some of the counts, but not all of them. So that's procedurally where we're at. We're at that 12b6 motion to dismiss part. The motion to not delete your shit was resolved by a stipulation between the parties. That means the attorneys got together and said, okay, there's this like civil litigation obligation to like preserve evidence and whatever. So we agree that we will preserve evidence and whatever. And if we don't preserve evidence, we agree that Salty can still file motions for contempt, motions for civil punishment, which in this case would be stuff like sanctions or jury instructions. Like there can still be litigation over the motion to not delete your shit, even though it was stipulated to. So the parties agreed, yeah. Well, yes, it's good. We agree. And which is nice because the court is like, oh, good. You agree on this basic ass thing that is an obligation in all civil lawsuits. Perfect. After that, there were shenanigans on the interwebs. And then there was Salty's response. I was like, there were shenanigans and then Salty's response and then more shenanigans. So there were internet shenanigans, then a response to the motion to dismiss. So KJ, Katie Joy, and Without a Crystal Ball, the defendants in this case, filed that motion on jurisdictional grounds and other things. Salty responded saying, we believe there's jurisdiction because of this, and we believe there's misstatements made in the declarations because of this. And that is broken down in other videos. Then more shenanigans happened online. Like more shit happened. And we have receipts of the more shit that happened. So because more shit happened from the time that the response to the motion to dismiss was filed, and the response was filed December 24th. Like it literally was filed on Christmas Eve. It is January 5th. And on January 4th, we had a new precipice filed. The precipice is essentially a motion to the court saying, there's new shit just happened, but relevant to our response. So it is seeking to amend and add more shit into the response to the motion to dismiss because new shit happened. When I talk about the fact that lawyers say if you're in a lawsuit, the first obligation you have is to shut the fuck up, this is why. Because now there's more. So now we have the precipice, which is essentially the addendum. Like, Your Honor, but wait, there's more. That's what's happening. There's a declaration from Salty, getting all salty. And then there is a kind of joint and confer or a meet and confer joint notice of discovery. And we will talk about that last because truly it's the most legally and there's so much stuff in the other stuff. So we're just going to have to We're just going to have, we need Lippy, and we're just going to have to jump right the fuck in. So let's pull this up and jump in to what Salty had to say. And make it big so we can see it. Make it even bigger so we can see it. I'm not going to be able to see y'all in the chat at all as we make this bigger, but just know I'll be back. All right. Look, precipes are something that don't happen in state court that I've experienced. This seems to be either a federal quirk or a Washington federal quirk, but it's essentially a, Your Honor, might I add more to my motion? And we will see what the judge says about that. But there is so much, and there's tea, that I can't imagine the judge saying no. And we'll just get into it. So, pursuant to the local rule of court 7M, plaintiffs submit this recipe. It's like recipe, but not quite. I'm going with recipe to add an additional document in support of their previous filing. That's going to be the declaration of Salty. Plaintiffs seek to add into the record a declaration showing additional factual support for plaintiff's argument in docket 27. That's the response to the motion to dismiss on jurisdictional grounds. Jurisdiction meaning, hey, Washington, you cannot reside or preside over me. I am a resident not of Washington. That's in a nutshell. I have a bunch of videos about jurisdiction. Go watch them. Such information was not included with the previous filing. Sassy footnote number 1. Why? Set forth why the document was not included in the original filing and reference the original filing by docket number. These are the rules about what to do in a precipice. So it's just letting the court know the reason I'm saying this is because this rule says I have to. Because it only came to undersigned counsel, Salty's, attention after the filing of plaintiff's opposition. That's the opposition to the motion to dismiss. December 29, 2020, defendant broadcast a live stream video in which they discussed this lawsuit. Haven't we talked enough about the fact that that's a bad fucking idea? I think we have. Defendants broadcast a live stream video in which they discussed the lawsuit. The members only mode was on for live chat, in which a person using an account believed to be Lori-Ann Barnhart participated and sent paid super chats to defendants. The video definitively shows the person known as Lori-Ann Barnhart, whose online presence shows she lives in Washington. And that gets into this declaration that is in the opposition to the motion to dismiss. Other video. Was a paid member of defendant's channels as of the date of the video, which means Lori-Ann, who lives in Washington, is a paid member of Without a Crystal Ball's channel or Katie Joy Live's channel. Because Katie Joy operates both channels are connected together. I think she'd have a very hard time arguing they're not, because half the time it seems when she goes live on Katie Joy Live, the bottom little bit, see with me, it says at the Emily D. Baker. Hers often says Without a Crystal Ball. I don't think you can separate the two. I don't even think they'll try. This revelation prompted an in-depth investigation into the approximately 1,600 videos that currently are viewable on defendants' channels to determine if Ms. Barnhart's account was a member before the lawsuit was filed. The reason this evidence, words are hard. The reason this evidence was not discovered earlier is that the undersigned counsel did not have any knowledge that Lori-Ann existed prior to the filing of this lawsuit or her connection to Washington. I mean, tangentially, or that KJ would argue jurisdiction and then someone living in Washington being a member would become relevant. Added extrapolation. And the videos that establish her membership had innocuous titles unrelated to plaintiffs. So we didn't watch all of the shit. We only watched the shit where you allegedly defamed us. Defendants have so many YouTube videos, many of which are more than an hour long, that it would take years to view them all in their entirety. The knowledge that Lori-Ann is a member of defendants' YouTube channels only came to undersigned counsel's attention through defendants' broadcasting of the video about this lawsuit on December 29th, 2020, with the members-only chat turned on. This is coming up because of that video, which happened after the Christmas Eve, December 24th filing of the opposition. So this happened after that all went down. Undersigned counsel certified that they met and conferred, which means at some point Salty was like, hey, yeah, Michael Brown. Yeah, what the fuck, man? What's with this video? No, but she lives in Washington. Oh, yeah. Okay, well, we're gonna have to file a motion. Mhm. Yep. No, no, this is gonna be before the contempt motion. No, that's still coming. We have to get to this first, though. Right, because we need to supplement the record. Well, right, because your client keeps talking. Monuments to the gods of speculation. Undersigned counsel certified that they met and conferred. It means the attorneys talked and informed him of plaintiff's intent to submit this precipice with additional documents in support of plaintiff's opposition to defendant's motion to dismiss. Undersigned counsel also informed defendant's counsel that plaintiff would stipulate to allow defendants additional time to submit their reply, meaning it's like, hey, we added shit later. You can have more time, which really is the upstanding thing to do, right? And then it's signed by all of the attorneys for the Washington firm and Salty for the California firm, certificate of service. And then we get to the declaration. Now, I have put them into one document. Yes, they're 3 different documents. Declaration. Woohoo! Declarations are fun. All right. Michael Saltz is saying who he is, why he's making a declaration. Specifically, since the filing of plaintiff's opposition, defendants have disclosed additional evidence confirming that, contrary to the statements made in defendant Paulson's. Oh, we're to Catherine now, because we were Katie and now we're Catherine. It keeps changing. Not in Salty's motions, but in her declaration, she refers to herself as Catherine Paulson, but in the lawsuit, this is filed against her as Katie Joy Paulson. I don't think it's shade. I just think this is attention to detail that the declaration is made by Catherine Paulson. Either way, contrary to statements made in defendant Catherine Paulson's declaration, docket number 19, filed in support of defendant's motion to dismiss, defendants have knowledge that they derive income from residents of the state of Washington. Such evidence confirms that said income is derived through super chats and paid channel memberships in which they have entered into contracts to provide in exchange for a fee exclusive content and services to people defendants have reason to know are Washington residents. So the argument is a channel membership is a contract, and the contract is, hey, if you pay a monthly fee, you get access to these things, and I provide these things to you as a channel member. Because defendants failed to disclose, we're gonna keep like beating on the fact that this declaration was misleading in all of these motions. This is just what we're going to see every single time. It's going to be, remember it's misleading. Remember it was failed to disclose. And the thing is, if you didn't fail to disclose it, they can't argue it like this. But this is not ever going to be let go. This is what we are going to see throughout all of this. We are going to see failed to disclose, misled the court, on and on. Because defendants failed to disclose that they derive income from the performance of their contractual obligations to provide exclusive content to known Washington residents through paid memberships on their YouTube channels, this evidence of defendants deriving an income from known Washington residents did not present itself until a week after filing of plaintiff's opposition. What is more, this got yellow because it was what is more, said evidence was made more difficult to find and otherwise comprehend due to the fact that there have been a concerted effort to obfuscate and or destroy such evidence. So this hits on both the motion or the declaration from KJ being misleading and failing to disclose, and it hits on deleting your shit. In one paragraph, it's like, not only did you lie to the court in your declaration, but also we are saying that you have intentionally and willfully, obfuscate, made it hard for us to define evidence by deleting shit. So now the court is made aware that this is plaintiff's position about the delete your shit. And at some point, the court is going to be like, oh, okay, well, we're going to see an order to show cause why there should not be contempt proceedings based on the violation of the stipulation and potentially based on the declaration that was misleading. By way of example and not limitation, meaning, but wait, there might be more. I watched and simultaneously recorded a video because you have to at this point. You have to simultaneously record because shit keeps disappearing. A video entitled All of This Needs to Stop that was streamed live on December 29th, 2020. Do y'all think this is a clickbaity title? I want to know. Tell me in the comments. on defendant Katie Joy Live YouTube channel, footnote 1, because we're in the declaration now. We're not in the motion anymore. That's why the footnote started over. The Katie Joy Live YouTube channel is a subsidiary of Without a Crystal Ball, of the Without a Crystal Ball YouTube channel, wherein defendant Paulson now streams live content that is apparently of a more personal nature, or where the lawsuit gets discussed. One or the other. During the December 29th, 2020 video, defendant attempted to downplay their otherwise previously public connection to a member of their YouTube channel, Lori Ann Barnhart. Right after Lori Ann got flamed in the declarations of the original opposition to the motion to dismiss. Lori Ann Barnhart, who is now known to me to be a Washington resident. This member named Lori Ann is identified by her YouTube assigned author ID, and they list it as well as her personal identifier on YouTube. Regardless of what published name she uses on YouTube, the author ID remains the same. She is also the same person known as Lori Ann with the accounts, and they go into the Twitter accounts, profile ID on Facebook, and the same person assigned to profile ID, whatever on Facebook for the account has used the names Lori Ann Barnhart and more recently Lori Ann Prione Lori Ann Prione. This same Lori Ann is identified to be the person that is referenced in the declaration of Kim Fulner submitted by plaintiffs in conjunction with their opposition. And then it gives the opposition docket number. I've broken down that declaration in the other video. During the All This Needs to Stop video, a person using said Lori Ann YouTube account sent defendants multiple super chats evidencing direct commerce, like I am paying you, direct commerce between a Washington resident and defendants, as stated in the declaration of James Westbrook. And it gets into relaying how James Westbrook broke down what a super chat is, so the court's aware of how the money transacts, and then it cites which docket number that is. And then there's screenshots of Lori Ann saying Tati's lawyer is a creep that needs a restraining order. He has been passive aggressively me since I have been the most vocal in standing up for you. This is all my fault. Well, just not to get into the grammatical stuff, but the reason that it's relevant that Lori Ann is a ride or die for KJ is because KJ's arguing that there's no ties to Washington. Lori Ann lives in Washington. She's a channel member paying from Washington, and she is super chatting from Washington. I think it is a salty bonus that Lori Ann came after him on Twitter when all of this went down. And accused him of not being a lawyer and all of that. You guys have seen the screenshots. They're all over the Twitters. But I think that just happened to happen. If KJ wasn't arguing jurisdiction, the Lori Ann fuckery wouldn't be relevant. But because she's a resident of Washington, this becomes very, very relevant. And these super chats are direct commerce with the state of Washington, which is something that is an element or a consideration in the jurisdiction arguments, and it directly goes against what's said in the declaration by KJ that's submitted to the court in connection with her attorney's motion. Moving on. Additionally, below is a true and correct copy of a screenshot of another super chat sent from said Lori Ann YouTube account to defendants that defendant rebroadcasted in the video portion of the live stream that I obtained while watching said video at approximately 72 minutes therein. Lori Ann said, I can't believe you're even entertaining this guy, Katie. He's sick, violent, and a harasser. So is PJ. I don't know what any of this is referring to, but it's just showing the fact that these super chats are being made in videos that are after the opposition was filed, meaning it's known to KJ, to her business and her attorney, the connection between Lori Ann and the state of Washington. And this is the same picture that was in the Twitter profile that was blood tall, whatever. This development is significant because, as stated above, this person that I know as Lori Ann is also known to me to be a resident of the state of Washington, a fact that has been presented in plaintiff's opposition and which Lori Ann has effectively admitted herself in unsolicited messages sent from her Twitter account to me shortly after the filing of said opposition papers. What the... Y'all. If you are mentioned in a lawsuit in some way, the lawyer that mentioned you is not the person you want to go ahead and reach out to. If you are mentioned in an opposition like this, maybe reaching out to the attorney on the other side, KJ's attorney, and saying, I mentioned this lawsuit. What does it mean? Is it a problem? Do I have any recourse? If those are the questions you want to ask, reach out to that attorney. Do not reach out to the attorney that puts you on blast in a declaration. And the only reason you're in the declaration is because of the close connections established on social media between KJ and Lori-Ann, and the fact that Lori-Ann lives in Washington, showing both connections to the state and that there are very apparent false statements now in this declaration, because it says no contacts, no subscribers, no viewers in the state of Washington. And this contradicts that. But reaching out to the attorney, not a good idea. To be certain, said messages expressly state that plaintiffs, and especially myself, doxed her, and then they define doxed, by stating that she had been doxed. Lori-Ann appears to have admitted that her personal identifying information is true, as one cannot be doxed with information that is not their own. And then this is the DM. The DMs. There are DMs. There are screenshots of fucking DMs in a legal filing. It's like a T video on paper, on pleading paper, in format. It's in 26-line format for the judge. I suggest you stop doxing me and accusing me of doing things I haven't done. All of these trolls that surround you are the harassers. You call yourself a professional, yet you allow your troll army to dox me. Unless you have proof I have done anything even close to illegal, you best stop it. You have already doxed me, and I don't even know who the hell Tati is. I don't believe that for a second. Nor have I supported Katie for months because I was harassed and stalked. Now, this was on December 24th, so she might have resumed her support. I don't know what level of paying member she is of KJ's channels, but support their super chats a few days later. However, that's all irrelevant. The support of KJ is irrelevant. It's the fact that there's known contacts with the state of Washington, that the declaration states otherwise, and that it can be proven through this. Also, the declaration from not from Salty, but the declaration in the opposition goes to behaviors and screenshots and statements made, but all tying it into the state of Washington. Also, we've talked about this a lot, but let's just. Do y'all remember when we talked about litigation privilege? Do y'all remember that? Like the stuff that happens in it's like Vegas, but legal. Like the stuff that happens in litigation is protected in litigation. So the stuff in those declarations is protected under litigation privilege. Those declarations in the opposition are offered to prove that there are sufficient contacts with the state of Washington for Washington to have jurisdiction. They serve the dual purpose of proving that there are things plaintiff is alleging in KJ's declaration that are false and or misleading to the court. So it serves two purposes, but the heart of the thing is to say, yes, there's jurisdiction here. Can we please move the fuck forward with this case? That is the point of all of these declarations covered by litigation privileges, which means there's nothing Lori-Ann can do if she doesn't like being in those declarations. In the declarations, you can't sue Salty over it. It's in the course of litigation. So it seems that Lori-Ann is salty because she, DM'd Salty up on the Twitters. Now back to Super Chats. Said Super Chats from said Lori-Ann YouTube account to defendants through defendants' YouTube channel establish that defendants do earn an income derived from the state of Washington. A true and correct copy of the video without the live chat because, I can't even get my live chats to save at the moment. But without the live chat or comments I had downloaded from defendant's YouTube channel can be viewed here. And there's a Dropbox link. Said super chat screenshots show at the bottom of each respectively that said live stream limited to participants of ongoing live chat, said video to members only. For said video to members only, membership to a YouTube channel involves a monthly fee. And now we're getting into the membership because now we've got recurring income being paid to a channel from people known to live in Washington, i.e. Lori Ann. And then they get into others. They go through the levels of membership on the channel. The footnotes get into what it is. We do define stan though. Just let me just point you to footnote number 5. A stan is a social media vernacular for a person who is both a stalker and a fan of a particular personality. I would add that the phrase stan did come from an Eminem song. And I'm dying to know if Salty has heard such Eminem song, Stan, because that is where the phrase Stan came from. We are giving it to Eminem. That is who coined the phrase Stan in his song Stan. Anyway, that's where Stan came from. And then it came back around that everybody's like, no, I stan. Fair. Anyway, stalker and a fan, but kind of with a good, I stan is kind of with a positive connotation, not like a negative, scary, stalkery connotation. But I digress. I'm not Urban Dictionary. All right. Then we get into the levels of the channel. This is Katie Joy Live. But you see, again, it's right here. There's no way they're going to be able to argue. I don't even know if they'll bother. They probably won't. But you can't argue that Katie Joy Live is not affiliated with Without a Crystal Ball. That's not going to happen. It's not going to fly. So they go through the different levels of membership and then talk about membership for the Without a Crystal Ball channel and show the different membership levels for the Without a Crystal Ball channel and talk about what those are. So these are superfan, standing, and next level. So that gets into it. And then they talk about the color of badge, indicating, just like we started seeing teal badges on this channel today, the different colors of badge indicate the different level. I don't think they show it on here, but the different colors of badge indicating the different level of membership, how long you've been a member, et cetera, et cetera. Salty goes on to say, after I had determined through the evidence cited above that said Lori Ann YouTube account was a paid member of defendant's YouTube channel, I then attempted to determine if said Lori Ann YouTube account had been a paid member of defendant's YouTube channels prior to filing of this lawsuit on October 30th, 2020. This required that my staff and I research and review the 65 videos remaining. Footnote 7. The reason why I describe these videos as remaining on said channels is because defendants appear to have deleted and or privated numerous videos on their YouTube channels since the filing of this lawsuit. See declaration of Michael J. Saltz in support of plaintiff's motion to preserve evidence, not delete your shit, docket 9, and accompanying exhibit C, docket 9-3. So this is sass and shade. I know it looks like I wrote sus. That's sass. It's sassy and it's shady, but it's again pointing out to the court. This is pointing out to the court from the plaintiff's perspective. Hey, court, plaintiffs have been hampered in answering this motion thoroughly to argue jurisdiction because of the willful actions of defendants. That's the argument here. And this is the subtle ways they weave it through this whole motion, saying to the court, look, we can't discover all of this because of what they're doing. That's exactly why there is a stipulation to preserve evidence. And by the time we get to addressing in court, we here on the YouTube's chatting about it, the royal we, by the time we get to addressing in court the motion to, the order to show cause re-contempt with regard to the motion or the stipulated agreement to not delete your shit, and with regard to the declaration, the court's already well aware. It is woven throughout this, but it's relevant, saying, hey, we couldn't have put these in our argument because of the actions of defendant. So they've made it very relevant, and the court is going to have this in the back of their mind when we get to those motions down the road that I imagine will be filed. You can't not file a contempt motion. If I'm looking at this from plaintiff's perspective, after this motion and the way it's laid out, you know that a contempt motion is coming. I just thought it was going to be the first thing we saw. But I also didn't watch that entire video to see all the super chats to go, oh, no, you got to amend the jurisdictional stuff first and deal with that and deal with the down the road motions. So this is getting into an older video now. So this is a June 9th, 2020 video indicating that Lori-Ann is a channel member from then. I had downloaded this YouTube video directly from YouTube without live chat to a Dropbox for the court's convenience. Screenshot verifies that Lori-Ann YouTube account name had a paid membership loyalty badge next to it that is only available to members of defendant's YouTube channel that pays defendants a reoccurring monthly fee. So it's got the little icon in there. Again, goes to show that in June, this individual who they've identified as a Washington resident is paying a monthly reoccurring fee, which they are arguing is a contract to provide extra bonuses and content. And that again shows both a connection to the state of Washington. Oh, I didn't pull this back up. Sorry, y'all. This again shows a connection to the state of Washington, but it also shows income derived from the state of Washington. And it also shows, again, that the declaration said that there wasn't, but in fact, they're showing videos that say that there is. And that is going to be a thing. I said it was going to keep coming up. It keeps coming up. So this is showing the membership icon. This, again, is the same image that was on the Twitter account in the other. And this one, same image, and then same image that's on this one. So same profile picture, not unusual. Moving on. Where did we go? Here we go. All right. I've lost my place. I'm trying to find my place. Recurring monthly fee. Here we go. Generally, the presence of that loyalty badge next to the name Lori-Ann on the video screen means defendants have entered into a membership contract to provide Lori-Ann said loyalty badge plus other exclusive content and services. As such, I had newly discovered this evidence indicating defendants were receiving an income pursuant to a contractual relationship that they entered into with a resident of the state of Washington and who coincidentally defendant Paulson publicly stated was her best friend. The reason this evidence was not disclosed prior to the filing of plaintiff's opposition, here we go, back into it, was that I did not have any knowledge that Lori-Ann existed prior to the filing of this lawsuit or her connection to Washington, and the videos that established her membership had innocuous titles unrelated to my clients. Like, why the fuck would we watch it? We're not watching this whole channel if we don't think there are defamatory statements. And now you've argued jurisdiction, and now you've poked the bear. We're going to find all the shit. And all the shit's going into this precipice to say, look, here are more contacts to the state of Washington. Defendants have so many YouTube videos, many of which are more than an hour long. So are mine. that it would take an outsider like me, who is naturally unfamiliar with the contents of said videos, years to view and catalog them all in their entirety. The knowledge that Lori-Ann is/was potentially a paying member of defendants' YouTube channels only came to my attention through defendants' broadcasting of this video on on December 29th with the members only chat turned on. So this is how I discovered this connection. If this video hadn't been made, would this connection have been discovered? Not if there wasn't a super chat, because it wasn't relevant for Tati's attorneys to pay attention to, because they never knew that the jurisdictional argument was coming or that this person lived in Washington until everything started coming up. When I say don't make the lawyers look more closely, don't ask the lawyers to look more closely at you, because this is why. At this point in my investigation, I was able to determine that there had been a concerted effort to hide and therefore make it difficult to find evidence of a known connection between defendants and the person known to me as Lori-Ann Barnhart. Specifically, I discovered that the aforementioned Lori-Ann comment that was rebroadcast on the video screen in said June 9th, 2020 video, along with other Lori-Ann comments in said video's live chat, have now been deleted. Oof. So we have the date. We know that there's a comment here If this video was still live, I imagine what Salty or someone on his team did was went to see where the chat scrolled this before it was pulled in. The way I pull comments in, the chat scrolls and I pull comments over, but it doesn't take the comments out of the chat. They still show up in the chat when that's done and when the chat replays on the video. Oof. So now we've got to, okay, it looks like comments have been deleted. I thoroughly scanned the entire live chat for said video and could neither find the subject rebroadcast Lori-Ann comment, this one, nor any other Lori-Ann comment anywhere in said live chat. However, I did find indications that multiple comments from Lori-Ann's YouTube account did previously exist in said live chat by way of example. I personally observed other participants of said live chat during the June 9th, 2020 live stream video were directly conversing with the person using Lori-Ann's YouTube account in said live chat. And then there are screenshots of people talking to, don't forget Tina at Lori-Ann, I did, thanks. So now there's evidence that a conversation was happening, but the Lori-Ann side of the conversation is missing. And that is the argument going in. But all of the statements and or responses from the side of Lori-Ann's YouTube account and said live chat conversations were deleted and are now missing. That, again, this is where Salty is making the argument. There is this concerted effort to now hide these connections. Oof. Thereafter, I discovered that all of the previously identified Lori-Ann live chat comments from defendants' aforementioned live stream videos on December 29th, 2020 were also deleted. Y'all, in addition to the deletion of all of said Lori-Ann comments as stated above, I discovered that the aforementioned Lori-Ann YouTube account had been permanently deleted sometime after defendant's broadcast on December 29th, 2020 live stream. So I imagine if you deleted, and let me know in the chat what you think, or let me know in the comments what you think. I imagine if you delete your entire YouTube account, that it pulls and deletes every comment that you've made on any video everywhere. But that's not good. Furthermore, I also discovered that said Lori-Ann Facebook account and said Lori-Ann Twitter account at Bloodtall were also deleted with close proximity of the time that said Lori-Ann YouTube account was deleted. The deletion of the social media accounts that I know to belong to Lori-Ann occurred after her connection to defendants was disclosed in plaintiff's opposition, including but not limited to the existence of direct messages between Lori-Ann and defendants. And that's in that screenshot in that motion. And I break that down as well in the other video. It is my belief that the deletion of Lori-Ann's social media accounts was in response to the presentation of evidence of a close relationship between defendants and Lori-Ann Barnhart. Further, on January 2nd, 2021, I observed yet another live stream on defendant Katie Joy Live YouTube channel in which additional relevant information regarding even more known paid Washington members was disclosed, and this gets into another video. At around 35 minutes into said January 2nd, 2021 live stream, a person using the name Addie Talking Trials and Stuff, which is the YouTube handle of a paying member that is identified as having a contract with defendants to receive exclusive content services, paid member, states in a members only live chat she lives in Washington State, and then later apologizes for mentioning her state. And these are the screenshots of her saying, "We live on a side of a hill in Washington State. We've learned to deal with the yellow pollen." So again, saying there are these direct contacts to the state of Washington, and then saying, "Sorry, my fault. I mentioned my state." At 38 minutes into said video, in this declaration, it's words just got hard. In the declaration, it states that around 38 minutes into said January 2nd, 2020 live stream, defendant Paulson tells her members not to share where they live. Defendant Paulson said, "Please don't ask people where they live. Don't talk about where you live in general. If you live somewhere, that's fine." Now, this can be taken two ways. This can be taken as, hey, don't share your personal information on the internet. Or in the context of a motion to dismiss based on jurisdiction, it can be taken as, hey, my channel's being watched. Every time you say you're from Washington, it seems to end up in a court document. So I think that can be taken two ways. Clearly, Salty and Tati are going to argue it's being taken towards this goes directly against what's in the declaration, and this goes against you winning this motion. It is apparent that this statement from Defendant Paulson was a response to Addie, who had since apologized in the live chat for sharing that she was from Washington, and thus proving further evidence of the fact that defendants not only have actual knowledge that they have a contractual relationship with another resident of the state of Washington, but that defendants have actual knowledge they continue to derive additional income from the state of Washington through reoccurring monthly membership fees paid from residents within the state of Washington to defendants through their YouTube channels. This newly discovered evidence identified herein is additional evidence that defendants have not been forthright in their motion to dismiss with regard to their contacts in and income derived from the state of Washington. Not only should defendants have known at the time Defendant Paulson signed her declaration that they had contractual relationships with Washington residents from which they derive an income, but also defendants most certainly now know that they have contractual relationships with Washington residents from which they are most certainly deriving income. That is a gauntlet being thrown down, and I'm going to talk about that in 1 second. All of the evidence set forth above conflicts with Defendant Paulson's statements in her declaration, docket number 19, at paragraph 4. To my knowledge, neither I nor Without a Crystal Ball, which would be WACB, has any sponsors or subscribers in Washington. To my knowledge, neither I nor Without a Crystal Ball derives any income from the state of Washington. I declare under penalty of perjury. Under penalty of perjury, just like KJ did in her own declaration. We are going to get in just 1 second to the evidence motion or the discovery motion, but I don't even need to pull it up. You saw it. I was going to pull it up. You've seen this. You've seen the language. You've seen the statement. This is the statement that's coming up regarding the jurisdiction motion. To my knowledge, neither I nor Without a Crystal Ball has any sponsors or subscribers in Washington. Why I said the gauntlet was thrown down when Salty said that defendants now know is because the challenge there is, if you are KJ and KJ's attorney, do you at this point withdraw the motion to dismiss now that it has been so attacked and that the declaration has been so attacked that if you continue moving forward, will it make the court more upset continuing forward with a declaration that now the other side is saying, you now know that this is false, and yet you're still arguing it to the court? So could KJ's lawyer say, we're withdrawing the declaration? Yes. Could they withdraw the motion? Yes. Could they withdraw the declaration and the parts of the motion that rely on the declaration? Yes. What that would do is save them from arguing it in court, saying, based on later discovered evidence, we are now withdrawing this because we have seen that these statements are not true. Will that happen? I don't know. Would that be a conversation I would be having right now? Yes. Also, the jurisdictional grounds on this, I think even you guys know that I was like, no, the research and stuff adds to the jurisdiction, but the apparent attempts to hide it based on what's being alleged here, the apparent attempts to minimize the contact between the state of Washington and KJ looks like a acceptance or a knowledge that there is this connection that goes against the grounds of this motion. I don't think with this on top of what was in the opposition that it puts the defendants in a very good position to win this on jurisdictional grounds. So if you don't win the jurisdiction, I mean, they're not going to win the 12B6 because the stuff's adequately pled. So then what? We've spent over a month plus, and the money it takes to do this to end up just back at the beginning of discovery. And I think that's what's going to happen here. But also, now you've added back at the beginning of discovery, you now have to answer the complaint. So more motions need to be filed because there needs to be an answer. And you now have this declaration out there where you can have the court evaluate it for perjury because you now have conflicting statements. If it's withdrawn, I think it helps with that. But you also have this stipulation to not delete shit, and now shit is going missing again, as alleged in this declaration. And so there is more litigation to come with this before we even get to discovery. It will be interesting to see if anything is withdrawn. It will be interesting to see if KJ's side decides to withdraw the entire motion and say, we're withdrawing the motion and the declaration to protect her in front of the court, or if they say, you know what, let the court decide it. We're not withdrawing anything. Let the court decide. Go ahead and bring your motions. We're not bothered. Bring them. Bring it. Bring it could absolutely be the strategy here. I don't think that would be my strategy when you have a declaration that said, to my knowledge. Well, your knowledge should be changed now because it's all in all the declarations. I don't know how you still argue that in good faith. So I know that some of the other lawyers in the space were like, I don't like that Salty was saying that's bad faith to put this forward, but I think continuing to argue that there's no knowledge at this point smacks of bad faith to me, and I would argue it too. The other motion is the joint status report regarding discovery. I only bring it up because A, it's time to talk about discovery, and B, there was a little bit of tea in here, and then we'll just jump in to questions. So it has been decided that they will wait on discovery, which is the exchanging of documents and information and requests and all of the lawsuit shit, until after the jurisdictional motion is settled, which is perfectly appropriate to do, because why even start spending the money and wasting your time with getting discovery until you know that you're going to be in this court? Like, you don't need the judge to start ruling on discovery motions until we know that we have jurisdiction, and the judge can't anyway until jurisdiction is discovered or determined, because you wouldn't be ruling on motions if you didn't have jurisdiction. So initial disclosures, the parties are filing a stipulation and proposed order to stay discovery, meaning pause. We're going to put a pin in this until we get done with the motion to dismiss. That stipulation and proposed order will include an exception that will permit plaintiffs to issue subpoenas for Lori Ann Barnhart's social media and internet content, as well as her communications with defendants that they believe may be lost in the absence of such subpoenas. The court orders are coming. The court orders are coming, because that's essentially a subpoena is a court order to, like, let me see your shit. Hello. Hi. Let me see your shit. I would like all of it, please. So that will all be subpoenaed. If defendant's motion to dismiss on grounds of lack of personal jurisdiction is denied, the parties agree to exchange initial disclosures within 14 days of the court's denial. And then this gets into the timing of discovery and the things that will be sought. The part to me that was the most interesting is now we know that subpoenas will be coming with regard to the social media accounts of Lori Ann Barnhart based on stipulation. That means that both sides have agreed. That means that KJ's lawyer has been like, yeah, we agree. We agree that with the other discovery, we're going to pause, but that yes, stipulations, we agree that now is the time to subpoena those documents, because it now seems that accounts have been permanently deleted. That removes comments off of YouTube channels. That removes content off of Twitter. But we know that once you subpoena, we know because we've discussed it, once you subpoena Twitter, YouTube, and Facebook, you should be able to get the contents of it. Remember, in the motion to delete your shit, the argument was, yes, you can get the contents of the words or the video, but you can't get the reach. That's not really the point as much here. So, y'all, it's so much stuff. So here's what I think will happen. I think that there's an outside chance that the declaration could be withdrawn or the motion could be withdrawn. There should definitely be, I would be having that conversation. Or we just wait for the judge to rule on this. I think there's going to be an order to show cause with regard to contempt, with regard to the stipulation to not delete shit. I think we're going to see more legal kerfuffling over the declaration. And if it's withdrawn, maybe not, but we'll see, because it was still put out there. I'm not sure. I'm not sure how I feel about that one. I know there's still been discussion about the defamation charges, but they weren't brought in that motion to dismiss. The more I think about it, the more I think it's strategic that those weren't brought, because only one of them has to stick in a 12b6 motion, which means the judge would be like, yeah, this one's good enough. And that kind of torpedoes your case at the beginning, because I don't think any of the defamation statements that are alleged would be dismissed on 12b6 grounds, on just your motion to dismiss grounds. So I just think that where we're at is waiting to see if anything gets withdrawn by the defense, or if this moves forward and what the court rules in this. So That's the breakdown. That's the breakdown. Let's jump back into the live questions. Thank you guys. That was a long breakdown. There was a lot of shit there. I'm going to try to get to everything I can. All right. So let's see. All right, guys. I saw my son pop into the chat as well. Hello, honey. How are you? Let me see what we've got in the way of questions that we can pull up. I know I missed some. I'm sorry. And we will get into these as well. Just remember, keep the chat civil. We are just talking about the lawsuits. We're not talking about the people. We're talking about the lawsuits. And we can talk about Salty being salty and sassy in his footnotes. K-Newt says, as Lori Ann isn't a direct part of the suit, would that mean that her deleting her own social media accounts, if it can't be proved KJ requested her to do so, would be legally fine? So the stipulation says anything you can control or direct. And I think that statement that they're friends might come up. So it's hard to speculate on, but the avenue that the plaintiffs are going to take on that is that this is a concerted effort. This is a group effort to delete these things. So we will see, but it will be subpoenaed and we'll see what's in the conversations, or the court will, somebody will see what's in those conversations, including emails and everything else, because that's all in the stipulated stuff that you have to preserve. And that stipulation goes to not just KJ's own stuff. Douglas says they should just withdraw at this point. There's so much proof and that's just hurting her more. I worry that that's the case for sure. Let me see. What is going on with KJ's lawyer? Shouldn't he have fact checked all of this? It's like one lie after another. This is, again, between the attorney and the client. You would have thought that the lawyer would have watched the videos with relation to the lawsuit, but we don't know what's going on in that relationship. The attorney might be relying on her representations. That's really between how they decide to run their relationship. I think that the conversations might have changed in tone with the receipts that keep coming up in all of these motions from Saltsy. You don't want to play with lawyers that are well versed in the social media realm in a case that's playing out on social media. We're at the beginning of the case, and it's just, there is so much information that the court is going to have about shenanigans and just absolute fuckery going on early on in this case that it's not good. This is a lawsuit. Lawsuits have a certain pattern. Judges expect to see certain things. Fuckery is not generally what they expect to see in federal court. That is shit that should play out on Twitter. This isn't Twitter. This is a federal judge that's going to be reading this going, what are you doing? So, and yes, I'm fucking Rakin has these documents up on Twitter. So if you guys want to see them, they are linked in that Twitter account if you want to go check them out, and always provides them for free to everybody, which is very kind. Allison, I can't imagine this case being less than 1.5 million in lawyers' fees. Oh, no, for both sides, like for each. Absolutely. So absolutely. So I see the comments about KJ's husband. I don't know anything about that situation, so I am not commenting on it. Other to the effect that she's saying just because he appeared on my YouTube channel doesn't make him a public figure, which I think is going to play into the argument that James Westbrook is maybe not a public figure. Because look, if defendant and plaintiff all agree that James Westbrook isn't a public figure, the defamation per se is pretty strong in my opinion anyway. But if she is saying just because he appears on my channel doesn't make him a public figure, what's good for the goose is good for the gander in that. But other than that, I don't know the situation well, and I'm not going to get into it. So it's going to be very, very interesting. Let me try to catch up in the chat a little bit. Thank you, mods, for keeping everything congenial. We are not here to drag people. We are here to talk about sassy footnotes and occasionally go, I don't even know what the fuck is going on with this. But we're not here to drag people. Actions, sometimes we're going to call into questions. Behavior, we will call into questions. We're not dragging people. Tiffany, do you think KJ lied about all those things to her attorney and he's getting blindsided by this. Possibly. A lot of this is coming up in videos. But I don't know what videos her attorney watched. Probably should have watched the 40 that were alleged in the complaint, but not all of this was there. Her attorney is on notice that the plaintiff's attorney is watching everything that's done, which means her attorney either needs to choose or would choose to either also watch everything as closely or rely on her recitation of it. And that is a choice that they will have made together. And that's a choice her attorney will have to make. He might be getting blindsided. We don't know. That is between them. Aang says, I'm so baffled by why KJ didn't try to work with the lawyers from the beginning and just stop harassing and on a mission to ruin Tati. She has a sea of people. She does this to just cover the cowards. I don't know who the cowards are. Cowards, I don't know who they are, but there were 4 cease and desist in this case. There was ample time to resolve it. It didn't get resolved. Oof. Now we're here. And we're just going to keep getting into this. So let me try to catch up on some of the thank you Diva views for saying hi. We have almost 6,000 people in the chat, so I missed stuff. Oh, there we go. Hi, buddy. Wait, is it lunchtime? It must be lunchtime. Travis, don't be watching while you're supposed to be distance learning. Oh, thank you, MJ. Yeah, we have 5,800 people watching. So the question was, so does that mean Lori-Ann has to answer to the courts? No, it doesn't. It means that the accounts will be subpoenaed and probably subpoenaed directly from the holders of the social media accounts because they are in relation to the motion, but it does not bring that up yet. It doesn't mean that's not a possibility. It just means at this point, that's not what's happening. At this point, it's getting into preserving and getting those accounts and the court issuing a court order saying, yes, you can subpoena these accounts. Yes, they are relevant to this case and going from there. Casey Louise said, is Lori-Ann obligated to preserve her comments and accounts since she is not being sued? Should KJ's lawyers have preserved all evidence left from Ireland? So the parties are going to argue over what that stipulation entails and what reason to know and control over means, because obviously a YouTube channel owner can't say, hey, don't remove your stuff. A YouTube channel owner cannot talk about the stuff, but also it is going to be damaging because the way that it's going to be argued by plaintiff is, see, she said in this video, that's my best friend, that's what we're alleging, and then poof, all these comments disappeared after it was put in this declaration. They are going to spin it to look a kind of way, and then it will be on KJ's side to argue, I have no control over what my subscribers do. I can't, control if they delete stuff or not, but it's going to depend when they get all of the DMs from the Twitter conversations and everything else. It's going to really depend on what was in those conversations. Yes, Claire S. Baird, there is so much stuff in this. So much stuff in this. It's, you guys, what do you think? It's crazy, yeah? Gizzy's travels again. There is argument. Okay, I need to read the question. The question, for those just listening, the question is, should KJ's lawyer or legal team have checked all the stats out before he has made a declaration? Can he not get in trouble for this? There was, I don't know, it was alluded to in Salty's opposition that some of the arguments put forth by Brown were in bad faith. Salty put that in that motion. But at the end of the day, the person who signed the declaration was KJ. So could he get in trouble? It depends, which is a hard thing to speculate because a lot of speculation would have to answer. Could the court strongly admonish, like, you need to know what's going on? Yes. Could this be embarrassing? Yes. Could his client get in trouble? Yes. Could there be penalties for a misleading declaration if it's not withdrawn? Yes, all of those things can happen. But at the end of the day, it's on the person who signs it to verify the veracity of it. It's on the lawyer to guide what that means and to make sure that they parse the words of, okay, well, are you 100% sure you don't have any subscribers in Washington? Like, go into your back end of your YouTube analytics and look if anyone's watching in Washington, because your YouTube analytics can do that. But that also might be where the attorney is not as familiar with YouTube as Salty is, because we know Salty represents other YouTubers, and that can be problematic. We'll see. We'll see what the court does with it. The court's not going to like this at all. Like, none of this. There's a lot of fuckery. There's a lot of fuckery for a federal court. This is a lot of fuckery for a federal court before we've even really gotten into litigation. So I think there is going to be more that comes from this. I think, I think this is going to be a problem. Haley asks, can the deletion of evidence translate into obstruction of justice charge and become a criminal matter? Haley, it's not obstructing justice in the sense that this is a civil lawsuit. Can there be civil penalties for the litigants in the matter? Yes, there can be, but obstruction of justice really goes to obstructing investigations more in the criminal and governmental realms. This is a civil suit. So this is a different thing. So there are lots of things to come in this case. I'm going to try to get to a few last comments, and then it is almost 1 o'clock. We have been live for almost 2 hours. There are 5,800 law nerds up in here. So can you guys tell me how many, did we get the thumbs uppy things? Tell me about the thumbs uppy things and where we're at with all of that, so that the algorithms can help everyone find the information. Uncannery, I think it's absolutely hilarious that Salty and his firm had to get a membership to KJ's channel to get the tea before she deletes it. I mean, I don't know if they're members, because some of those members only chats, the videos are up. I don't know if they have member only live streams or not, but we'll see. The Baking Theorist, I made a pie of your animated intro face yesterday. I have to go find it, but now I've seen the new podcast art and I may have to do a full-blown pie treat. You look cracking. Thank you so much. That's very sweet. I will have to, if you tagged me on social, I'll go look for it. Thank you guys. 100 thumbs up. I appreciate you guys so much. Can KJ's, and for those of you who are like, who is KJ? Katie Joy, we call her KJ. Can KJ's YouTube or social media accounts be subpoenaed, as she has deleted so much? I imagine that there will be a subpoena. I mean, but there shouldn't have to be. There's a stipulated order to preserve, but I think they'll do it anyway. Jennifer is absolutely correct. Jennifer says, Emily Friday, I'm done with this until more is filed today. Hold my mixed drink, hold my coffee, hold my kombucha and vodka. Because Salty was like, hold on, I've got receipts and screenshots. Oh, there was one thing I saw something on Twitter. And since we're talking about screenshots, I wanted to pull up what I saw on Twitter, because on the Twitters, there was screenshots of KJ defending Lori Ann on Twitter, saying Lori Ann's a private person. Salty, leave her alone. Let me go find that screenshot, because it is, I think I was tagged on it somewhere, but I've been tagged on a lot, so I'm looking for it. Scrolling the Twitters to find it, but there is I'll just describe it and see if I can find it. There's a screenshot that says, Lori Ann is a real person, leave her alone. And that was early on in the lawsuit. So I don't know, somebody tag me in it. Tag me in it and I'll see it. Maybe it was in my messages. Let me pull those up real quick and see. It was in here somewhere, but I'm not seeing it off the top of my head, because you all have tagged me in a bunch of stuff. So I will have to come back and find it, and I will put it up when I find that screenshot. But it's a screenshot of her defending Lori Ann, saying Lori Ann's a real person, leave her alone, at the beginning of this lawsuit, when Salty was saying, hey, Lori Ann, if you think I'm not a real lawyer, come to my office. Because there was interaction on Twitter with all of this before any of this went down in declarations. Like, the shit went down on Twitter before any of it went down here. So yeah, I don't see it. I'll find it. It's probably in my messages somewhere. And then I'll just post it on Twitter. So if you're not following me on Twitter, now's a good time. I'm at the Emily D. Baker everywhere. Let me see. When will a judge rule on these? So for the opposition to the motion to dismiss, because there has been added information to it, there's an additional 14 days for KJ's side to respond. So now we have 14 days and KJ's side has the opportunity to answer the opposition, and then a noting date will be set, and then there will be a hearing on it. That doesn't mean shit's not going to happen before. I was like, y'all, we're done. We're done until something else gets filed. We're never done. We're never done. I'm sure that's how Salty feels, because there are live videos on live videos. And I'm sure he feels like I am never done. So we have 14 days till a response from the day this was filed, which was yesterday. And then we will talk about what her side has to say, because we will see the defendant's response to this motion within 14 days, probably on the last day of the 14 days, because that's how civil works. All right, let me see. I missed some new members. Members, thank you and welcome. Kimberly, Mother of Rots, with a super chat. Will they search and ask for her sock accounts in Discovery? Possibly. I mean, Discovery, let's just talk about Discovery really briefly. Discovery is the process of gathering information from the other side. And the court will be expected to rule on motions. The court will be asked, like, we object to this discovery. We don't want to turn it over. We object to answering that. And the court will do that kind of litigation in the process of helping decide what's discoverable, what's not discoverable, what's overreaching, what's too broad, and all of that stuff. So there is an entire process of discovery that will involve the court. So it's not like either side can just go, all willy-nilly, going willy-nilly and find whatever they want. There is a procedure and a process. There are legal rules, and the court will be involved in that. Bunny asked a great question. Does Salty have to wait for their response before he can file a contempt motion? No, he does not. He can file an OSC whenever he wants to. So Glitter Girl said, Emily, I got your merch for Christmas and now I'm watching your videos wearing merch. Tag me on social if you take a picture of it, because I would love to see it. Speaking of merch, I haven't talked about merch in a million years. LawNerdShop.com. There's new stuff coming this month. It will go to the members first, but LawNerdShop.com is where you can find Law Nerd stuff, including the mugs, which are slightly delayed because of shipping overwhelms, but they will get there. So, question, can a lawyer fire a client who seems to continue acting against their own best interest the way KJ seems to continuously be doing? Again, the attorney-client relationship is something very specific to each attorney and client. We don't know the strategy behind this case. We don't know the conversations that are happening between them. Can attorneys just fire a client in general, not related to this case? They have to go through the court, and they have to say to the court, this is why I can no longer represent this client. The way that's played out for me in criminal cases is when attorneys have said, my client has threatened to kill me and multiple times, and I can no longer represent them. Please replace them with alternate counsel. It's different in civil because the person pays the attorney's appeared on the record, and there is some level of client control that goes with accepting a client, having a client pay you, different than like a criminally appointed attorney. But even if attorney wanted to leave a particular case, they would have to be allowed out by the court. So the court would have to say yes, because it slows down the court to bring in new counsel. New counsel has to get up to speed. They have to go back through, review everything, learn everything. And generally that will delay things by several months. At a minimum, delay things by several months. So it's up to the court at the end of the day, but client control is something within a attorney-client relationship that is really a discussion between the attorney and the client. And again, it could all be strategy, and we don't know. I can't understand. Like, I can't wrap my head around it, but that doesn't mean there isn't some kind of strategy to it. I just don't. I don't understand what the point is. Like, I see the point in some of the barbs that were thrown in the motion to dismiss. I see the strategy behind wanting that to be the story and wanting to share that, like, look, Tati wrecked herself with Sister. She said she was going to sue James not James. She said she was going to sue J Star and Shane Dawson, and she said all of this, and so it's deflecting from me onto like, this is the real problem. Why are you picking on me? And that's kind of the story that was told in that motion. I understand wanting to get that information out there and wanting to feel like you've been heard in your legal documents as well, especially because we're all talking about this case because, shit keeps happening. But I don't understand the strategy of allowing this to keep going. That's what I don't understand. So it's just, okay. The wrap up number 2. Wrap up number 2. Question: did you see the screenshot that Salty did of Uncivil because I live? I did see it. Uncivil, were you soliciting screenshots? Because I think that's the situation. That screenshots were solicited. But hey, I like it. Why not? It's fun. It's all in good fun. So, Amelia says 14 days. We'll see on how long that. We'll see. I mean, we'll see what happens. We've got 14 days and something else will be filed. We'll see. Let me see if there are any other questions I can get to. I wanted to make sure I missed Tamara's super. Hold on. I want to try to make sure I at least sweep the last super chats. Samantha, would you ever represent yourself if you were sued? It depends on the circumstance, truthfully. But before I made that decision, I would consult with at least one other attorney that I trusted, if not 2, because the thing about more brains being better is it's very hard to think your way around a problem when you're in it. You need someone else to come in with the external strategy and to see the avenues that you don't see. It's very much easier to see the other avenues for something when it's not actually your problem. When it's involving you, it becomes more emotional, and it's hard to be logical when you're emotional, even if the emotion is, this is fucking stupid. I shouldn't have to deal with this. We had a lawsuit that, it was the beginnings of a lawsuit that we dealt with through my husband's work. And even then I was like, nope, we're pulling in employment law attorneys because we need to have these conversations. Was I involved? Yes. Did we pull in external attorneys? Yes, absolutely. And so even if it was a friend of mine and I was like, look, I want to just be your friend and like stand by you and talk things out, but I want to help you get the right attorney and a right fit, I still wouldn't necessarily represent my friends depending on the case. So no, there is a very common phrase that says the attorney that represents themselves has an idiot for a client. It's because you need other perspectives without the emotion of it. And being sued is stressful. It's emotional. Going through litigation, suing someone is stressful and emotional. Litigation is not fun. Litigation fucking sucks. It's pressure. You need the attorneys that have already been like pressure hardened into rocks to do that because that's their job. I wouldn't do surgery on myself if I was a surgeon. I don't even know if you can do that. I mean, maybe surgeons put stitches in themselves. I don't know. Not a surgeon. Bad analogy. But you need that other perspective because you need that, law is reason free from passion. And when you're emotionally involved, it's very hard to pull the passion out of it to just have the blind reason. And so I would always talk to an attorney. Always. Even though I am an attorney. So, all right. Let's see if I missed anything else on the wrap ups. Jade, love you so much, Emily. Thank you. This is the first time I managed to catch a live, but watch them all on the catch up. Thank you so much. Glad to have you here. And for those of you watching on the replay, thank you for still being here. I mean, we're at the end. Oh, I lost something. Hold on. Glitter Girl, did I get a shiny ho-oh? No, I still haven't gotten a shiny ho-oh. I've been working too much to raid adequately to achieve that. And I have not gotten to play Pokemon Go nearly enough. So yes, no shiny ho-oh for me just yet. Kristen said I asked too early, so it got lost in the shuffle. I'm sorry, Kristen. Emily, do you feel that Salty's declaration is laying preliminary groundwork for his eventual OSC? I think that it is definitely, I don't want to say tipping his hand, but it is priming the court, like, this is what's happening, but it's also, that's what's happening. It's the story from their perspective. So this is the story from their perspective, and the story from their perspective is, this is what's happening and this is how it's going. So I think that Salty's declaration is definitely showing where these inconsistencies are. I also think it's almost a shot across the bow of, we've laid it out with regard to this declaration, and we've laid it out with regard to the contacts with the state of Washington. It'll be interesting to see how they respond, because they're going to have to respond to all of that. I mean, they don't have to. They can choose not to, but the court's going to want to know why it's not being responded to. So we'll see. We'll see in 14 days. Tassie, this all goes to jurisdiction and possible perjury, but do you think it will actually impact the case other than the contempt motion? At this point, yes, and here's why. Because if there are discovery sanctions, meaning stuff was deleted, stuff was removed that made it harder for the plaintiffs to investigate their case, there will be a instruction to the jury that happened, and juries do not like that. It also is going to a contempt, in order to show cause regarding contempt early on in a case, can definitely make it more contentious with the judge. So yes, it can impact the case. Everything that's going on in court now impacts the case. I mean, jurisdiction staying in Washington impacts the case in that it's clear that KJ's side wants it to be removed out of Washington to be in Minnesota for their own strategy and reasons. So all of this impacts the case. Losing these initial motions impacts the case. It also signals to one side or the other. It's like, you've spent all this money on this motion, because motions aren't inexpensive. I mean, we're talking tens of thousands of dollars to do this pre-litigation work. So this is a lot of money to spend on a motion, and then to lose it, and then have to start the very lengthy discovery process in this case. So yes, I think all of it impacts. A ho-oh is a Pokemon. We speak fluent Pokemon around here. So Emily, send your kids out to seek your shiny ho-oh and claim it's their PE. I should. We don't have a lot around here, unfortunately, so it does generally involve driving. We definitely moved out into the country. We can see stars. We just can't see very many Pokemon gyms. All right. Jamie asked, can Salty use the court of public opinion to show how KJ is perceived? I don't think we're far enough along to play that out into how it will play out in front of a jury. What's happening in the court of public opinion right now is that Tati has said quite a lot about this case without saying anything about this case. Tati has not been on social media. Tati has not been promoting Halo products. Apparently Uncivil's been promoting Halo products. I'm getting tempted to now try Halo products, like, because we've just talked about it so much. But what we're seeing is Tati being able to stand up for herself in the way of these court filings and get her story across. We wouldn't have this much of the story if this hadn't happened. If there hadn't been chatter and fuckery on social media in between the filing of the complaint and now, we would have had a complaint filed. We would have had a jurisdictional motion. The jurisdictional motion would have been contacts, no contacts, and then would have been arguing the videos that came before. So what would have been argued is the research-based and all of that. The reason we have so much information from Tati's side is because of what the defense has been doing. Because the defense went over the page limit in their motion to dismiss, Tati's side was able to go over the page limit in their response. And because there was a request for judicial notice, they got extra pages. The request for judicial notice and the opposition to it is where all the tea was. Like, the building monuments to the gods of speculation was all in those extra pages because there was that ridiculous request for judicial notice of YouTube videos that's not going to be granted. But what it did is gave page limits for Tati's team to keep making her side. So there is a PR strategy component to this. And in that, Tati has gotten to speak quite a lot without speaking. And what we're seeing is responses even in things in James's declaration, in the motion to dismiss, and then I have to wrap up, but in James's declaration to the motion to dismiss, we see him sniping at the Clark Swanson complaint. And the Swanson complaint is a sworn complaint by Swanson saying, no, Swanson knew that we had moved because he filed it in our corporate declarations. So now we're seeing stuff in this lawsuit also speaking to the other lawsuit saying KJ's side relied on a statement in the Swanson case saying that we lived in LA. But even Swanson knew that that wasn't true when he filed that case because he had filed our corporate declarations with our Washington address. So we're seeing quite a lot play out in what information is being shared in this suit. And the Swanson suit plays so heavily into this because but a number of the statements with regard to the defamation were in KJ's video saying the Swanson complaint says this, but they were statements that weren't in the Swanson complaint. So just on its face, it's like the Swanson complaint says this, okay, but the Swanson complaint doesn't say that. So that's part of the alleged defamatory statements is the misreporting of the Swanson complaint and what it purported to say. So in the court of public opinion, which is where I started talking about this, the behavior of the defense in this case has given Tati lots of room to share the story from their perspective. And I think so far, let me know. Do you guys think that's playing out in Tati's favor? Because I think it is, but I would love to know if you think it's playing out in Tati's favor or not. I mean, y'all now know what a saltsy is and everybody's obsessed with a sassy footnote. And now lawyers that don't file with sassy footnotes, we're all going to be like, but why? Why aren't there sassy footnotes? Don't you know we want to talk about them? Okay, we got to that. Wrap up number 4. Thank you for the super sticker, Bugsy. I appreciate it. Thank you guys for your support. I love seeing the chat. It's going very fast today. Sasha said, I missed your podcast because I'm at work and it's my second day. Congratulations. About to rewatch the one with the AirPod in my ear. Love the channel. Thank you, Sasha. Congratulations on second day at work. It's got to be a weird time to be changing jobs with COVID still being what it is. So yes, Chartreuse Seeker said, yes, this is playing out in Tati's favor. Cosmic Slice says it's absolutely playing in Tati's favor. Her staying quiet is a good move on her part. I love seeing what you guys are thinking. Diva, I'm going to go with Dava. If I pronounce that wrong, I'm sorry. Thank you. Tati won't run out of money. That's the other thing, is that the money in this becomes a big factor. And Tati's side is perceived to have the greater funds. I think that's the common perception. We don't know. We don't know that for sure. That is the perception. I laughed last night so hard on the Tati vitamins. Okay, so what we're saying is that an Uncivil, I don't know if you're still in the chat because I've been talking for fuck ever, but what we're saying is we need Uncivil to start taking Halo and like report back. Like now we need like a 30-day, 60-day, 90-day trial of like the Kiwi vitamins or something. I think that's what we need now. We need to know. Anna says, love all the sassy footnotes. We do love the sassy footnotes. They're gel. They're just very sparkly gel. I saw the word tangent. I was like, I want to know what tangent we're on. Emily, a little tangent, but would it be too shameless of me to promote my Redbubble designs for building monuments over here? I asked on IG. I will go look on IG. I want to make sure that I will go look on IG. I want to make sure there aren't copyright issues because technically what's written in a complaint can be copyrighted by the lawyers. So I will go take a look on it. Thank you. Uncivil is here. See, we're going to want a 30, 60, 90, your impressions of Halo. That's what we need. That's what we need for sure. Rachel is in the UK and said, UK staying strong. Lockdown is horrible. Stay safe. Stay home. We can't leave our house now unless getting food or exercise. Rachel, that's a very hefty lockdown. That's what it was like in Los Angeles in March when we started the first lockdown, and leaving the house to get groceries still felt very, very, very overwhelming. Truth Sleuth coming in with the recommendation. Halo stuff is next level. I took them for months. So look, if people like the formulas, I've heard lots of people like the formulas. Uncivil's like kiwi vitamin C. You're going to have to go for it, Uncivil. Holly Michelle said, my job rudely interrupted my enjoyment of your stream to make me do worky things. Well, worky things. Just wanted to say hi. Thank you, Holly. Thank you very much for being a supporter. And I am going to, you guys, I'm going to have to get go. Everybody loves the kiwi. This is great. Question, isn't KJ due for a response of some sort soon? Michelle, 14 days for a response to this. And then 14 days for a response to the opposition to the motion to dismiss. And there was a stipulation with regard to the motion to not delete your shit. So that's really all that's coming up. So yes, happy birthday, Uncivil. Go join his channel. Brandis, thank you for shouting out Uncivil. Uncivil, happy birthday. I didn't know it was your birthday. So happy birthday. And if you're on the text chat, you'll get one. So anyway, everybody, thank you in the chat for popping in and saying happy birthday to Uncivil. Very, very civilized of you, chat. I appreciate you. All right. Wrap up number 17. Thank you very much. All right. We have been here way too long. I appreciate you guys. You know the YouTubey things. You know where to find me. And when I find those photos that I was talking about, I will post them on Twitter, and I will probably clip this down and post a lawyer reacts of just the breakdown of this. So if you missed any of it and want the cleaned up version of that, I will edit it down and post it for you all too. It has been like an hour, 2.5 hours. You guys, I've talked way too long. Thank you for being here. I will see you again on Wednesday for a premiere of a new video at 11 a.m. Thursday evening for members only chat, and Friday for Friday Night Live. Stay well. I will see you soon. Thank you for being here, and thank you for all your support. Connect with me everywhere. I'm at the Emily D. Baker. The podcast is the Get Legit Law and Shit podcast. So if you're ready to ride it on, head over to lawnerdshop.com, your place for all your law nerd needs, stickers, t-shirts, sweatshirts, and more coming soon. If you guys want to join the text, just text emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you support what we do here on the YouTube